Hey, hi everyone. My name is Sarah. I'm with the Shelter Island Public Library, and I'm here with Terry Lucas and Mara Zonderman for Talking the Bill of Rights. This is our third session. And I just wanted to thank a couple of our East End libraries that we are in cahoots with. Big thank you to the Westhampton Free Library, Amagansett, Cutchogue, East Hampton, Floyd Memorial, Hampton Bays, Mattatuck Laurel, New Suffolk, Quogue, Southold, Port Jefferson, and Riverhead. I may have missed one or two, so I apologize. And I'm going to pass it off over to Mara, I believe. You're going to kick us off. So awesome. Thanks so
All right.
much.
I'm going to start by sharing my screen so that everyone can see our wonderful slideshow. Okay, so here we are back again to talk about the rest of the Bill of Rights, or sorry, not even the rest of the First Amendment. Last time we did sort of the beginning, or we did the chunk in the middle, freedom of speech and of the press. So now we're going to attack religion, assembly, and petition. And we're going to start with religion. So a little bit of history. So we're taught in grade school that the Puritans came to the New World to escape religious persecution, which is true as far as it goes, and explains this idea that we have that America was founded on ideals of religious freedom, but it's only a small part of the story. Those fleeing persecution in Europe did not come to America to share their new religious freedom with other dissenters, but continued to believe that society required religious uniformity to survive. Many of the colonial charters authorized the establishment of religious institutions, which all inhabitants would be required to support and attend. Anyone who chose to follow a religion other than the established one, or none at all, would still be subject to taxes or tithes, and might also be subject to imprisonment, public flogging, the stocks, or even in some cases, capital punishment. Over the next 100 years or so, however, religious diversity increased across the colonies, and some colonists began to think that maybe this whole establishment thing was not a great idea. Um, and particularly, there started to be a lot of disapproval of these draconian punishments. By 1785, when Virginia's tax levy for the church was due to be renewed, James Madison argued so forcefully against it that the proposal never even made it out of committee. Instead, the Virginia Assembly enacted Jefferson's Virginia Bill for Religious Liberty. The preamble states the case very clearly. All attempts to influence belief by temporal punishment or burdens or by civil incapacitations tend only to beget habits of hypocrisy and meanness. And the bill itself says, no man shall be compelled to frequent or support any religious worship, place, or ministry whatsoever, nor shall be enforced, restrained, molested, or burdened in his body or goods, nor shall otherwise suffer on account of his religious opinions or belief. Jefferson was so proud of the bill for religious liberty that it's one of only three things that are memorialized on his tombstone. You'll note that being president did not make the cut. So fast forward a few years, and we have the First Amendment, which is very similar to the Virginia Bill for Religious Liberty, but with substantially slimmed down language. Slimmed down enough, in fact, for there to be quite a bit of debate over what those 10 words actually mean. Congress shall make no law respecting an establishment of religion. Oops. What is an establishment? How should the courts define religion? The answer to the first question is still evolving. As to the second, the court generally takes the approach of not questioning someone's claim of religious belief, practice, or lack thereof, unless there's some clear evidence that suggests that the claim is spurious. If free exercise means anything, the courts have said, it means that no part of government gets to be the arbiter of what exactly is considered legitimate to freely exercise. And because the word religion is used only once to apply to both the free exercise clause and the establishment clause, it must be similarly broad as applied to both. So the courts must take a broad approach to what counts as establishing a religion as well. So let's look at the establishment clause first. You can't talk about the establishment clause without talking about Lemon v. Kurtzman and the lemon test, which has nothing to do with lemons, but I couldn't resist the background. So Lemon v. Kurtzman, it's a combination of a few cases involving state statutes that provided aid to parochial schools in the form of salary supplements for teachers of non-religious subjects, or textbooks or other instructional materials. The court applied a three-pronged test. First, the statute or action must have a secular legislative purpose. Second, its primary or principal effect must be one that neither advances nor inhibits religion. And lastly, the statute or action must not foster an excessive entanglement with religion. And this is where the court found a problem with the statutes in Lemon. They found the legislative purpose was to advance education throughout the state. The primary effect was applied equally. The students in the religious schools were getting the same textbooks, the same everything as the secular schools, the sectarian schools, excuse me. But the court said the surveillance or supervision of the state needed to police grants involved in these cases puts a public investigator into every classroom and entails a pervasive monitoring of these church agencies by secular authorities. So it would just require too much of the state, the government, going in and saying, yes, this is okay, no, this is not okay. And as I mentioned a moment ago, they don't like to do that when it comes to religion. The court feels that it's not government's job to say what is or is not religious or a-religious or whatever. Technically, the Lemon test is the standard that is still applied in Establishment Clause cases. But in 1994, in a case that arose just down the road from me in the Center Moriches school district, Justice Scalia said, the Lemon test is like a ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles around. It is there to scare us when we wish it to do so, but we can command it to return to the tomb at will. When we wish to strike down a practice it forbids, we invoke it. When we wish to uphold a practice it forbids, we ignore it entirely. And he should know about that, as we'll see when we discuss the free exercise clause. But for our purposes, the Lemon test is the way to go. So the first part must have a religious or secular purpose. Case of Wallace v. Jaffrey in 1985. There's Mr. Jaffrey. He was a civil rights lawyer in Mobile, Alabama, and he was challenging an Alabama state law that set aside 1 minute at the start of each school day for meditation or voluntary prayer. This was an amendment to a previous statute that only mentioned meditation. And the sponsor of the bill, State Senator Donald Holmes, testified before the district court that the bill was, in his words, an effort to return voluntary prayer to our public schools, and that he had no other purpose in mind. So Mr. Jaffrey challenged the law on behalf of his school-age children. And although he was not the governor who actually signed the law, George Wallace was once again governor of Alabama when the case got to the court, and that's why his name is on the case. And the court said, in this case, there is clear evidence of legislative intent. It does not get much clearer than that, and therefore the statute is unconstitutional. Determining legislative intent can be a tricky proposition because you don't always have the sponsor of the bill stating in open court that he was trying to further religion with his bill. But Justice Douglas, in his concurring opinion, said that there is little doubt that our courts are capable of distinguishing a sham secular purpose from a sincere one. So even without direct testimony, the court at the time felt that they were smart enough to figure this out. And remember, the requirement is only that there be a demonstrable secular purpose. This comes into play, for example, in cases allowing parochial schools to receive state funding. We'll get a little more into that later. But in later cases, the court has said that even if some legislators have the intent of allowing religious schools to benefit from public funds, the fact that the state has a substantial and legitimate interest in ensuring that its youth receive an adequate secular education satisfies this prong of the Lemon test. So as long as there's no entanglement, which was the problem in Lemon, the courts have been willing to let that go as long as there is a demonstrable secular purpose. Okay, What about the effect? Neither advances nor inhibits religion. So they break this down into two parts. The first part is coercion. So does the law, the statute, or the action have the effect of coercing somebody's religious belief? The main case here is Engel v. Vitale, also arising right out of Long Island here. In 1962, the New Hyde Park School District had a policy of beginning each school day with what was known as the Regent's Prayer, because it had been written and promulgated by the New York State Board of Regents as part of their statement on moral and spiritual training in the schools. The policy was challenged by the parents of several students in the district, and the court struck down the policy, saying, "We think that the constitutional prohibition against laws respecting an establishment of religion must at least mean that, in this country, it is no part of the business of government to compose official prayers for any group of the American people to recite." Another case, some years, just the next year, Abington School District v. Shemp. In Pennsylvania, students were required to begin each day with the recitation of at least 10 Bible verses. And the practice was that the verses would be recited over the loudspeaker as part of the morning announcements. At the request of their parents, students could be excused from attending the recitation, although where they would go to escape the morning announcements, I don't know. But it was included that parents could request that. After a lengthy review of Establishment Clause jurisprudence up to that point, the court found that this too was unconstitutional. Justice Stewart, in this case, dissented on the grounds that sufficient facts hadn't been established to strike down the practice, but even he agreed, saying a law which provided for religious exercises during the school day and which contained no excusal provisions would obviously be unconstitutionally coercive upon those who did not wish to participate. And even under a law containing an excusal provision, if the exercises were held during the school day and no equally desirable alternative were provided by the school authorities, the likelihood that children might be under at least some psychological compulsion to participate would be great. However, it seems to me clear that certain types of exercises would present situations in which no possibility of coercion on the part of secular officials could be claimed to exist. Thus, if such exercises were held either before or after the school day, or if the school schedule were such that participation were merely one among a number of desirable alternatives, it could hardly be contended that the exercises did anything more than to provide an opportunity for the voluntary expression of religious belief. So what we have going on there is this idea that particularly when it comes to school children in the school, any kind of prayer or forced recitation of prayer or Bible verses is too coercive. Too much has the effect of potentially making school children say things that were contrary to their own religious faith. Fast forward 30 years, and enter Deborah Weissman and her father. This is the first time the court clearly formulated their coercion test. So in 1989, the principal of Nathan Bishop Middle School in Providence, I believe, invited a member of the local clergy to give an invocation and benediction at the school's graduation ceremony under a policy of the Providence public school system. Clergy were encouraged to give prayers that were composed with inclusiveness and sensitivity. Rabbi Guterman, the invited clergy for the class of 1989, gave a short non-sectarian prayer, as much as prayer can be non-sectarian as far as the non-believer is concerned. But the Weissman family had sought a temporary restraining order that would prevent any kind of prayers from being recited. And it was denied shortly before the ceremony. Because the Weissman family had other children going through the schools, and Deborah, of course, would soon go into high school, they still had standing to challenge this practice. And they did. They sought a permanent injunction that would prevent the inclusion of prayers at any public school graduation ceremony in the city of Providence. The Supreme Court granted that injunction, and because that, it became the law of the land. No more prayers at graduations. But why? Why did they do that? The decision to include prayers in the graduation ceremony is made by the principal of a public school, meaning the prayers bore the imprint from the state. And from a constitutional perspective, it is as if a state statute decreed that the prayers must occur. Participation in the graduation ceremonies are, in a fair and real sense, obligatory, even if not actually required to receive a diploma. Any student wishing to participate in their graduation would also be subject to the religious practice that was part of the ceremony. The Establishment Clause protects both the religion and the state or the citizen. The explanation lies in the lesson of history that was and is the inspiration for the Establishment Clause. The lesson that in the hands of government, what might begin as a tolerant expression of religious views may end in a policy to indoctrinate and coerce. A state-created orthodoxy puts at grave risk that freedom of belief and conscience which are the sole assurance that religious faith is real and not imposed. The undeniable fact that the school district supervision and control of a high school graduation ceremony places public pressure as well as peer pressure on attending students to stand as a group or at least maintain respectful silence during the invocation and benediction. What matters is that, given our social conventions, a reasonable dissenter in this milieu could believe that the group exercise signified her own participation or approval of it. And that is not permissible. So far, so good, right? We seem to be on a straight trajectory. The Supreme Court is building some pretty clear case law. Buckle up. Next, we're going to talk about endorsement. What does it mean when the state does something that implies its endorsement of a religion or religion in general over non-religion? So Lynch v. Donnelly. We're still in Rhode Island. 1984. The city of Pawtucket, Rhode Island, put up a Christmas display each year in a park owned by a nonprofit organization. The display had many pieces traditionally associated with Christmas, including a Santa Claus house, reindeer, Christmas tree, candy poles, carolers, and a large banner that read Season's Greetings. You can't really see it, but it's back there. Apparently, photographic technology has come a long way since the 80s, because I had some real trouble finding pictures where you could see anything at all. So it had all these things, these sort of secular, traditional representations of Christmas, but it also has a creche right in the middle. And there's sort of a close-up of the creche. The Supreme Court had no issues with having a creche included in the display. Why? The concept of a wall of separation between church and state is a useful metaphor, but not an accurate description of the practical aspects of the relationship that in fact exists, says the court. The Constitution does not require complete separation of church and state. It affirmatively mandates accommodation, not merely tolerance, of all religions and forbids hostility toward any. And just as a side note, if any of you, as I have been challenged by someone who says, it doesn't say wall of separation in the First Amendment. That's true. It does not. That term actually comes from a letter Thomas Jefferson wrote to the Danbury Baptist Convention in response to their congratulating him on his election. But he was a founding father, so he should know what they had in mind because he was there. Anyway, so there's that. It doesn't require a strict separation. It requires tolerance, accommodation. And, says the court, neither the members of the First Congress nor the Congress of 1789 saw any establishment problem in the employment of congressional chaplains to offer daily prayers in the Congress, a practice that has continued for nearly 2 centuries. It would be difficult to identify a more striking example of the accommodation of religious beliefs intended by the framers. So again, we're looking at legislative intent. Would the framers have intended to bar a display of a creche? Well, no, because they did not in fact, remove religion entirely from the public square. It would be ironic, however, if the inclusion of a single symbol of a particular historic religious event as part of a celebration acknowledged in the Western world for 20 centuries, and in this country by the people, by the executive branch, by the Congress, and the courts for 2 centuries, would so taint the city's exhibit as to render it violative of the Establishment Clause. To forbid the use of this one passive symbol, the creche, at the very time people are taking note of the season with Christmas hymns and carols in public schools and other public places, and while the Congress and legislatures open prayers open sessions with prayers by paid chaplains would be a stilted overreaction contrary to our history. Okay. Compare that to Allegheny County v. ACLU, which in this case was about two separate displays. The first was on the grand staircase of the Allegheny County Courthouse. Um, Again, can't really tell, but that's a creche donated by the Holy Name Society, a Roman Catholic group, with signage indicating that the creche was a donation. And it was topped with a banner that you can't see at all in the picture that says, Glory in excelsis Deo, glory to God in the highest. Also, we have this display in front of the Pittsburgh City County building, an 18-foot menorah next to the city's 45-foot Christmas tree. At the foot of the tree was a sign with the mayor's name and a text declaring the city's salute to liberty. The menorah was owned by Chabad, but stored, erected, and removed each year by the city. Note that only the menorah was challenged and not the Christmas tree. Relying on Lynch, the district court found that both displays were permissible, but the Court of Appeals, the district court, so the lowest court, the Court of Appeals found that in this case, there was no other way to understand the creche and the menorah as anything other than an impermissible governmental endorsement of Christianity and Judaism. The Supreme Court split the difference. The menorah is okay, the creche is not. Why? As to the menorah, the mere fact that Pittsburgh displays symbols of both Christmas and Hanukkah does not end the constitutional inquiry. If the city celebrates both Christmas and Hanukkah as religious holidays, then it violates the Establishment Clause. In Lynch, the court had already established that there were secular elements to Christmas celebrations, and here Justice Blackmun did some pretty impressive acrobatics to convince us that a menorah is equivalent to a Christmas tree as a neutral harbinger of the holiday season. Simply put, he says, it would be a form of discrimination against Jews to allow Pittsburgh to celebrate Christmas as a cultural tradition while simultaneously disallowing the city's acknowledgement of Hanukkah as a contemporaneous cultural tradition. Justice O'Connor disagreed that the menorah was a secular symbol, but said that the proper question to ask in this case was whether the city of Pittsburgh's display of the menorah, the religious symbol of a religious holiday next to a Christmas tree and a sign saluting liberty, sends a message of government endorsement of Judaism, or whether it sends a message of pluralism and freedom to choose one's own belief. And she agreed that in the context, it did not imply any endorsement of one religion over another. But this is a great example of why sometimes a single court decision encompasses so many different opinions. In this case, they disagreed about what question to ask, but came up with the same answer so that they could join together and give us a single ruling. In this case, that the display as a whole, the tree, the menorah, the sign about liberty, which I don't know what that has to do with the holidays, but whatever, could not be construed as governmental endorsement of any one religion or of religion over non-religion. And of course, then there were the dissenting opinions who disagreed with this altogether. To them, the Christmas tree is a religious symbol, the menorah is a religious symbol, and the theory under which government is permitted to appropriate particular holidays and religious objects to its own use in celebrating pluralism is rejected. The message of the sign announcing a salute to liberty is not religious, but patriotic. The government's use of religion to promote its own cause is undoubtedly offensive to those whose religious beliefs are not bound up with their attitude toward the nation. But as to the creche, why does that constitute endorsement when the menorah does not? Well, why is this creche different from the one in Lynch? Primarily because it stands alone. It doesn't have any secular symbolism attached to it, and nothing in the context of the display detracts from the creche's religious message. And here is the clearest statement of the court's endorsement test. Lynch teaches that government may celebrate Christmas in some manner and form, but not in a way that endorses Christian doctrine. Don't ask me. Here, Allegheny County has transgressed this line. It has chosen to celebrate Christmas in a way that has the effect of endorsing a patently Christian message. Glory to God for the birth of Jesus Christ. Under Lynch, nothing more is required to demonstrate a violation of the Establishment Clause. So as you can tell, I don't know how they wrapped their heads around that one because I don't get it, but I think we all understand what they're getting at. So as long as you put it all together, you can do all kinds of things in December that would probably not be allowed in March. Um, but okay, so those are the first two prongs. We have um, intent, we have coercion, we have endorsement. Let's talk about entanglement. That one is a little trickier. So the case of Woolman v. Walters comes out of Ohio. Ohio law authorized various kinds of funding for non-public schools. So this is where we sort of break down this issue of school funding into what they can do and what they can't do, including such field trip transportation and services to non-public school students as are provided to public school students in the district. So, in other words, the same kind of funding that you could have for field trips if you go to public school, you can have in a non-public school. Some of the other parts of the law uh, allowed non-public schools, the majority of which are religious, to purchase the same textbooks, to get the same diagnostic services, hearing, vision services, that kind of thing, as public school students. And the court, by and large, said all that kind of stuff was okay because there's no there's no opportunity for the religious school to get its own message in there, right? It's the same textbooks. It's vision screening. It's, that kind of thing. But when it comes to field trips, because the non-public schools had control over the nature and timing of the field trips, and because although a trip may be to a location that would be of interest to those in public schools, it is the individual teacher who makes a field trip meaningful. And I'm sure any teachers we have with us today would agree with that. The field trips are an integral part of the educational experience, and where the teacher works within and for a sectarian institution, an unacceptable risk of fostering of religion is an inevitable byproduct. We need not and do not assume that teachers in parochial schools will be guilty of bad faith or a conscious design to evade the limitations imposed by the statute and the First Amendment. We simply recognize that a dedicated religious person teaching in a school affiliated with his or her faith will inevitably experience great difficulty in remaining neutral. The public school authorities will be unable adequately to ensure secular use of the field trip funds without close supervision of the non-public teachers. This would create excessive entanglement. So as we said before, if you can give the money without having really to do anything to make sure that they're not using it for specifically religious purposes, that's probably okay. If you have to get in there and make sure of that, then it's probably not okay. That is the super fast version of the Establishment Clause, although not quite fast enough. But let's move on to the Free Exercise Clause. One of the biggest questions about the Free Exercise Clause: does the Free Exercise Clause require or even permit exemptions from generally applicable neutral laws for religious purposes? And I will confess that 26 years ago, when I was a senior in college, that was my thesis question. And this is my opportunity to share my thesis with you. And I will tell you that it stood the test of time pretty well. All right, but we have to go really far back. Reynolds v. United States, 1878. So Mr. Reynolds, there he is, a resident of the territory of Utah, claimed that as a member of the Church of Jesus Christ of Latter-day Saints, or the Mormon Church, the law criminalizing polygamy placed a burden on the free exercise of his religion. The court said two things that were important. Belief may not be legislated. You want to believe that you need to be polygamous? Go right ahead. But actions, actually having more than one spouse, even those that stem from the religious beliefs, can be legislated. If the law only applied to polygamy that did not have a basis in religious belief, that would introduce a new element into criminal law and would impermissibly penalize non-believers when believers were allowed to go free. So they couldn't say in the law, you can't, have more than one spouse just because you want to, but you can if your religion says, right? That's not allowed. Then they went on to say that the government sometimes has a compelling interest in outlawing certain kinds of behavior that could be considered against peace and good order, and that this would override any claim of religious liberty. Can a man excuse his practices to the contrary of peace and good order, because of his religious belief? To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect, to permit every citizen to become a law unto himself. Government could exist only in name under such circumstances. So Reynolds was actually sentenced to 2 years imprisonment. Um, After he served his 2 years, he married his third wife in 1885, so about 5 years later. Um, and he had a total of 32 children. And this, I found one more picture. This is him in 1905, so sometime after his imprisonment, with his 12 sons. Apparently, his 20 daughters did not want to be photographed. Um, okay, so just keep Reynolds in mind. All right. Next up, we have Cantwell v. Connecticut. This is not a picture of Mr. Cantwell, but this is the only picture I could find that shows this phonograph that the Jehovah's Witnesses would carry around when they went door to door, soliciting donations and converts, basically. So the challenge was to a Connecticut law that required religious solicitors to obtain a license prior to soliciting money, services, subscriptions, or any valuable thing for any alleged religious, charitable, or philanthropic cause. And they would do this by playing records, among other ways, of playing records of their founder reading certain tracts. And the court said, unlike in Reynolds, in which the action, polygamy, could be regulated even though it arose from religious belief, in Cantwell, the action, solicitation without a license, could not be regulated because it arose from religious belief, and because the granting of the license would require the Secretary of the Public Welfare Council to make determinations as to what was and was not a religious cause, which is not something that a government official can decide. Okay, so belief can't be legislated. In 1878, action could. In 1940, action could not, until we get to Minersville School District v. Gobitis, also 1940. In this case, a Pennsylvania law required that public school students and teachers begin each school day with a flag salute and the recitation of the Pledge of Allegiance. Now, keep in mind, at this point, the Pledge of Allegiance did not include the under God bit that was added in the 50s. So we're not talking about that right now. But Jehovah's Witnesses, Lillian and William Gobitis, were expelled from school for refusing to say the pledge. And there they are with their father who sued on their behalf. The court found that a state had a compelling interest in ensuring national unity, which would result in national security, and that this goal ranked higher than nearly anything else. The precise issue to be decided is whether the legislatures of the various states are barred from determining the appropriateness of various means to evoke that unifying sentiment without which there can ultimately be no liberties, civil or religious. And here, that's not specifically the Gobitis children or the school district, but that is as they would have been reciting the pledge in 1940. To allow conscientious objectors to opt out of saluting the flag and saying the Pledge of Allegiance might cast doubts in the minds of the other children, which would themselves weaken the effect of the exercise. Not only was there a compelling reason to salute the flag, there was also a compelling reason to mandate that every student and teacher participated. Otherwise, the symbolism of the salute could seem meaningless to those who did participate. Okay, that's 1940. I don't need to mention what else was happening in the world in 1940, but 3 years later, a case that was virtually identical to Gobitis was brought before the court. In this case, it came out of West Virginia and involved the Barnett children, who we see here. And by 1943, forced patriotism was starting to seem like less of a good idea. Not only because of what we had learned about the spread of Nazism, but also because of the backlash that religious minorities, specifically Jehovah's Witnesses, were subject to after Gobitis. And there was a lot. Those children were, to say bullied doesn't even begin to describe it. And it was not just them, it was Jehovah's Witnesses across the country. So the court took another look. In 1943, the court still believed that national unity was a reasonable goal for the government to pursue, but did not give government free license to pursue the goal, saying the freedom asserted by these appellees does not bring them into collision with rights asserted by any other individual, nor is there any question in this case that their behavior is peaceable and orderly. To sustain the compulsory flag salute, we are required to say that a Bill of Rights, which guards the individual's right to speak his own mind, left it open to public authorities to compel him to utter what is not in his mind. Essentially, the court is saying that it is a violation of everything that the flag purports to stand for, to force those for whom saying the pledge conflicts with their religious beliefs to salute it, making the recitation a meaningless ceremony before a meaningless symbol. Far better to require respect for the flag at all times and provide the opportunity for salute for those for whom it would carry meaning. Um, and they went on to say, where there's grave and present danger, which we heard about before, um, the standards might be different, but in this case, nobody's being harmed by these children choosing to stay silent. I'm going to actually skip the next case because I'm going on way too long here. And we're going to jump right to Sherbert, which is where the court put down their real test. Okay, so there's Mrs. Sherbert. She wanted to not have to work on Saturdays as a Seventh-day Adventist, but her job said they moved to a 6-day work week. You have to work. She filed for unemployment. They said that her claim was denied because she failed to take work that was reasonably offered to her. And the court said, no, because she could not be made to choose between um, exercising her right to a state benefit and her religion. Um, Governmental imposition of such a choice puts the same kind of burden upon the free exercise of religion as would a fine imposed against her for her Saturday worship. Um, so this is the compelling interest test, and just keep this in mind. And you might hear compelling interest test, sometimes it's referred to as strict scrutiny, it's the same thing. Whether the disqualification places a burden on the free exercise of appellant's religion. Whether some compelling state interest justifies the substantial infringement of the appellant's First Amendment right. Okay, and then third, I don't know why I don't have this on here, but it has to be the least restrictive means possible to achieve the state's goals. For some reason, also not, there we are. The court added to this in Wisconsin v. Yoder, which involved and yes, Wisconsin v. Yoder added the part of the test that not only does the interest in the law have to be compelling, but also that denying the request to be excused from the law, denying that also has to be compelling. So here we have the compelling interest test. And there have been quite a few cases, but basically this is what the court has been doing with the compelling interest test.
Yeah.
It was either a roller coaster or a pendulum. I couldn't make up my mind. It goes up, it goes down. They say yes, they say no. But by and large, that is still the test, sort of, that is used to determine whether someone's free exercise is being abridged. I could go on for hours, but I'll stop. And we'll go on to talk about the right of the people to assemble.
So the right of assembly and the right of petition is a little less intense in some ways than the religion section of the First Amendment. But it's an interesting one because in some ways both of those rights have kind of been subsumed into the right of free speech. So we're going to kind of see how that happens as we go along here. So the next slide is basically when the Constitution was written, the right to petition and to freely assemble were especially important as these rights had been denied by King George III. And in the more modern times, the Supreme Court had treated the right to assembly as being part of the freedom of speech, as I said. But I think we always have to remember that, first of all, the construction of the First Amendment has changed over time and will continue to change over time. So we can't drop any of these important freedoms off and ignore them. And an assembly is more than the chants or the words on the sign. And a petition is more than the words on the petition. So we want to look at these as these rights and freedoms as standalones. So over the years, some scholars have argued that because the clause refers to a singular right, that the clause only refers to the right to assemble to petition the government. But earlier drafts of the Bill of Rights contemplated that each would be a separate right. So next slide. James Madison's early proposal for the First Amendment in June of 1789 combined the words, "The people shall not be restrained from peaceably assembling and consulting for their common good, nor from applying to the legislator by petitions or remonstrances for the redress of their grievances." So, and then the House later debated a consolidated text that was kind of similar to that one. And then during the debate over this First Amendment, Thomas Sedgwick of Massachusetts said that the right of the assembly was redundant with the freedom of speech. And he said, if people freely converse together, they must assemble for the purpose. It's self-evident, unalienable right, which people possess. And no one would question it. But Representative John Page of Virginia rebutted this assertion, saying, Sedgwick supposes the right of assembly no more essential than whether a man has the right to wear his hat or not. But let me observe to him that such rights have been opposed, and the man has been obliged to pull off his hat when he appeared before the face of authority. Therefore, it's well to guard against such stretches of authority by inserting the privilege in the Declaration of Rights. If people could be deprived of the power of assembling under any pretext whatsoever, they might be deprived of every other privilege contained in the clause. And after that, it was the right to assembly was continued to be contained in the First Amendment. And in the final draft, they say that the way that it is written is really just a matter of style rather than substance. So it's all these arguments have come out around because of the way that somebody tried to make the sentence a little shorter. So we're going to go to freedom of assembly. I think this is really an interesting right because it's the only right that involves more than one person for its exercise. You have to have, you usually have to also contact other people in order to arrange to assemble. Therefore, planning for assembly is often deemed to be protected despite not being specifically spelled out. So, where did the right to assembly originate? It was not specifically set forth in the 1215 Magna Carta, but it did become part of English constitutional law as part of the right of petition. It was limited sometimes by riot acts, and there were certain other acts prohibiting types of assembly based on religion. So it wasn't as strong until we started looking at the drafting of the Bill of Rights. An incident in the next slide that influenced the founding fathers in drafting the Bill of Rights and including the freedom of assembly was a case against William Penn and William Mead for delivering a sermon on the streets of London to gathered Quakers. There was a 1664 law called the Conventicle Act, which I really like the name of that, the Conventicle Act, banned any nonconformists from assembling for religious purposes. Mead and Penn were eventually acquitted, but the case was really well known and considered when about the time that they were drafting the Declaration because or the Bill of Rights, sorry, due to the large number of Quakers in Pennsylvania. So, next slide. So after independence, each state adopted its own constitution. And I think when we talked about the history of the Bill of Rights, we talked about how a lot of the states' constitutions were deemed to be the ruling document over the Bill of Rights initially and the Constitution. Massachusetts, New Hampshire, Pennsylvania, North Carolina, and Vermont included the right of assembly in all of their constitutions. And also it was included with processes for seeking redress of grievances. These rights were understood as a way to achieve popular sovereignty and allow people to directly influence the government. So, despite the debate about the perceived importance of this clause, it's been interpreted, and some say misinterpreted, over the years in a variety of ways by the courts. So, we'll go into some cases here. The next slide. So this is kind of a difficult picture, I'm sorry, but in 1876 in the United States versus Cruikshanks, This is one of the first examples where assembly clause was interpreted by the Supreme Court. And in this case, there was an armed white militia, which involved a massacre of what's believed to be over 150 Black freedmen who were protesting the 1872 Louisiana election. The court held the right of the people peaceably to assemble for lawful purposes, with the obligation on the part of the states to afford it protection, existed long before the adoption of the Constitution. The First Amendment to the Constitution, prohibiting Congress from abridging the right to assemble and petition, was not intended to limit the action of the state governments in respect to their own citizens, but to operate upon the national government alone. So I'm going to cut out some of the rest of that quote, but basically the Chief Justice here seemed to limit the freedom of assembly to one purpose, which is the purpose of petitioning the federal government for a redress of grievances. And this interpretation persisted for many years. So it was a really limited freedom because of that interpretation. But people kind of didn't pay attention to the courts and continued to claim a broader purpose for the Assembly Clause. And at the turn of the century, suffragists, the labor movement, and a growing political movement among African Americans resulted in many examples of gatherings justified by the Freedom of Assembly Clause. And these protests and marches proceeded despite the laws meant to curb this type of assembly. So in the next slide, the importance of assembly in politics and legal discussions could be seen in 1927's Whitney v. California. And this Anna Whitney was in the beautiful hat there, was convicted under the California Criminal Syndicalism Act. And it seemed at this time there were quite a few syndicalism acts in the individual states. And she helped to organize a group that sought to affect economic and political change through violent means. This is what she was accused of. She argued she hadn't intended this organization to act this way and did not plan in it to aid those objectives, and claimed that the California law violated the First Amendment. Despite having her conviction upheld, Justice Brandeis said, those who won our independence believe that freedom to think as you will and speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile, that with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. So this is one of the first times that speech and assembly were linked. And unfortunately, I believe that the clear and present danger law was applied here to her words, although it doesn't sound like that's exactly what they were trying to do. This next picture is Mr. Dirk de Jong. This was 1937, and the court once again made freedom of assembly applicable to the state as well as federal action. Actually, they started to kind of expand this freedom of assembly a little bit at this point. And in this case, the court found that Dirk de Jong was not guilty under the Oregon criminal syndication law. It's very hard to keep saying criminal syndicalism. Anyway, by simply promoting and assisting at a meeting run by the Communist Party. And at this, again, we're kind of looking at the time frame here, 20s and 30s. There was a lot of concern about communism. The World War I was over, but World War II was kind of hovering at the edges. And so people were concerned about political dissension. So Chief Justice Evan Hughes says, freedom of assembly cannot be denied without violating these fundamental principles of liberty and justice, which lie at the base of all civil and political institutions. The greater the importance of safeguarding the community from incitements to the overthrow of our institutions by force and violence, the more imperative is the need to preserve the constitutional rights of free speech, free press, free assembly in order to maintain the opportunity for free political discussion. Therein lies the security of the republic, the very foundation of constitutional government. So now we're kind of looking at this all a little bit differently. The next slide, in Hague v. CIO, somehow this case got mixed up with the 1939 World's Fair. I found this kind of fascinating that somehow the World's Fair and this case with the CIO kind of got mixed up together. In this case, the court struck down a city ordinance that allowed the mayor the right to permit or deny any group to gather in public. And this was whether this Jersey City ordinance was constitutional, because it was used to prohibit a group to meet and hand out literature about the National Labor Relations Act. Justice Roberts, in an opinion that Justice Hugo Black joined in, found the ordinance to be unconstitutional in this case. He described the right of assembly as one that is not absolute, but is relative and must be exercised in subordination to the general comfort and convenience and in consonance with peace and good order, but it must not, in the guise of regulation, be abridged or denied. So here they're saying you can regulate a little bit, but you can't deny it just because you want to. Okay, the World's Fair part of this is the next slide. There were these sculptures that were created in depicting the four freedoms, which were created for the opening of the World's Fair. And they were preceded by a number of speeches introducing the four freedoms, explaining what they were. Dorothy Thompson was a well-known journalist at the time, and she introduced the freedom of assembly sculpture in a speech during which she said, "The right to meet together for one purpose or another is actually the guarantee of the three other rights." About a month after the opening of the fair, the decision in Hague came down, and the New York Times pronounced in a big headline, "The right of assembly reasserted. All four freedoms of Constitution are well established." Done and dusted. We're good. We don't have to worry anymore. But here comes World War II. As we have found, as we're looking at the Constitution, a lot of things had a lot of changes during that period of time. So when President Roosevelt redefined the four freedoms a little bit differently, because he wanted to build up some support for the war. So he changed the four freedoms to freedom of speech, freedom of religion, freedom from want, and freedom from fear. So this assembly and press kind of got dropped out and was no longer really considered part of the four freedoms that had been so kind of popular and promoted within, the United States at that time. So, in fact, really kind of since that time, there haven't been a lot of cases that were explicitly decided on free assembly grounds. Free assembly comes up sometimes, but it's not the usual reason. In a relatively more modern case, addressing the freedom of assembly in 1971, which may not seem more modern, but for the freedom of assembly cases, it's more modern. Coates v. Cincinnati came before the Supreme Court. That's the next slide. Coates was a student involved in, I guess we can leave that. Yeah, was involved in a demonstration with respect to a labor dispute, and also with respect to the Vietnam War. So the people who were appealing this decision kind of had mixed purposes, but they all were in disputes about assembling. There was a city ordinance that said if three or more people meet together on a sidewalk or street corner, they must conduct themselves so as not to annoy any police officer or other person who should happen to pass by. Now, I think that is quite the standard. So the court found the ordinance to be unconstitutional under the due process standard of vagueness and the constitutional right of free assembly and association. And here's association sneaking in here that wasn't ever specifically stated in the Constitution, but it's kind of gotten to be known as one of the rights granted under the Constitution. Chief Justice Stewart described the right of assembly as protecting the right of the people to gather in public places for social and political purpose, and found the ordinance prohibiting annoying assemblies as containing an obvious invitation to discriminatory enforcement. And I'm looking for the part at the end here about basically, he said, what's annoying to one is not annoying to another. And this just leaves this a little bit too much open. And it cannot constitutionally do so through the enactment and enforcement of an ordinance whose violation may entirely depend on whether or not a policeman is annoyed. So I think this is a pretty easy place where you say the decision made sense, at least. So the freedom to assemble has not gone away, but as we discussed, it's more often combined with other rights and sometimes is kind of included in this idea of a freedom of association. But I do think it's going to get interesting as there's going to be some cases coming along, probably within the next few years, given the number of large protests that have been happening over the last couple of years. And it'll be interesting to see how this court treats freedom of assembly or whether they address freedom of assembly. So we're going to go over freedom of petition pretty quickly here because we just have covered a lot today. So the Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. And so the little history on this we can kind of get through quickly, but this goes back to the Magna Carta, and then which it's just such a beautiful document there. And then in 1669, the House of Commons resolved that every commoner in England possessed the inherent right to prepare and present petitions in case of grievance. And the House of Commons was going to receive these and to judge whether they were fit to be received. And then finally, in 1689, the right of subjects to petition the king and all commitments and prosecutions for such petitioning were to be illegal. So not only could you petition, but they couldn't prosecute you for petitioning. Next slide. So American colonists were allowed to exercise these rights. And when the Stamp Act hit, they were mad. And they decided to take their freedom and petition the king. And they continued to petition the king, and they continued to petition the king, and the king did not pay attention to them. And finally, in 1775, they sent the Olive Branch Petition as a last attempt to convince the king to address their grievances. And this is when the king announced that the colonies were in rebellion. So not a good outcome for that. Next slide. Soon after that, the Declaration of Independence was drafted and specifically said, in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. So this was important at that point. So we're just going to kind of quickly go over some different petitions that have happened over our history here. So starting back in 1836, in the next slide, there began to be a number of different petitions against slavery. And they received, in 1836, more than 300,000 petitions. Now, there weren't that many people around in 1836, so 300,000 was pretty substantial. It annoyed the House, who adopted a gag rule and said, we're not going to look at these anymore. After 5 years, John Quincy Adams repealed that rule, and they kept delivering petitions. And it's believed to some extent that all of these signatures on the petitions helped influence the government in passing the 13th Amendment. The next slide, and then we have suffrage. And in 1848, the first big meeting of the women's suffrage movement gathered in Seneca Falls. They created a giant petition. Again, this was an example of where the petitions went on for years and years and years. So I'm not sure how effective they were, but they continued to petition. In the next slide, there was a procession of petitions in New York involving a parade with suffragettes delivering more than 1 million signatures. And this helped them in New York, where in 1917 they were actually won the right to vote prior in statewide prior to winning the vote in the entire country in 1919. So again, the petitions came, and hopefully they swayed some people, but it's a long fight from 1848 to 1919. Next slide. In the 1960s and 70s, there were quite a few protests of U.S. involvement in the Vietnam War, and petitions began to take some more creative forms, our standard petitions, standard letters. But this was 1,300 active duty service members who published a letter calling for protests against the war. And it made an impact. If you publish that in the New York Times, the people that represent you in Congress are gonna know about it. By 1975, the U.S. withdrew from Vietnam, and hopefully these petitions convinced representatives that their constituents were not supporting this war. Next slide is 2014, the people of Flint, Michigan began circulating petitions. This is a little bit more modern, not completely, but a little more modern, to local, state, and federal government about the state of their contaminated drinking water. They petitioned for the tests of water. They petitioned for the tests of children who were experiencing lead poisoning. They went door to door, soliciting signatures on these petitions, trying to get someone to pay attention to them. Finally, they petitioned the EPA, and the EPA intervened. Both the Michigan legislature and the Congress passed laws providing support, recovery, and prevention efforts, which would seem to be a success. Unfortunately, residents of Flint are still fighting to have the efforts fulfilled. But in this case, the petitions of the people were heard and did make some difference in their lives. So again, there are pages and pages of places where petitions have been used to try to talk to legislators, to try to talk to the government. And again, sometimes they're successful, sometimes they are not, sometimes they're ignored. They're not required. The government is not required. These are not instructions. They're petitions. They're requests. The government is not required to grant your petition. They're required to look at it, supposedly. So, as you can see from this slide, there are so many places you can go now to join in a petition. It makes it very easy. I did a petition today for funding for libraries, and I get an email. It says, sign this petition. It's a letter to our legislator about why libraries are important and why we need the funding. And so this is where, from pen or quill and ink to the internet today, people are still petitioning and hoping that the people that represent them in the government pay some sort of attention to them. And so this is what we have today. And sometimes they can make a difference. And that's why I'm grateful that we still have this freedom, even though I'm not sure it's always as effective as we would hope it would be, or as effective as it was back in the day when there weren't so many people around. But basically, the Supreme Court hardly ever talks about the right of petition in their decisions. But it's important to realize it is one of our rights, and it was important to the founding fathers. The National Constitution Center says one of the risks of representative democracy is that the elected officials may favor the narrow partisan interests of their most powerful supporters, or choose to advance their own personal interests instead of viewing themselves as faithful agents of their constituents. A robust right to petition is designed to minimize such risks. By being forced to acknowledge and respond to petitions from ordinary persons, officials become better informed and must openly defend their positions, enabling voters to pass a more informed judgment. So that is, again, the First Amendment. We could probably take each freedom and spend an hour, but we only took you 5 minutes past an hour. If anybody has any questions, I think Mara and I would both be happy to answer them for you. Again, thank you for your patience with the change up, but as you can tell, it's hard for us to fit all this information in a very short period of time. And I'm going to look at the chat here
We do
to
have a
see.
few questions.
Okay,
Yeah.
what do we
Um,
have
the
here?
the first one is states that require the Ten Commandments to be hung in schools. I think they were just curious on which states
Mhm.
they were.
Mara, that's
Well,
you.
I don't know which states require it. I do know that um, generally speaking, the courts do not approve of that. Although sometimes, if the Ten Commandments are displayed as part of like a legal history sort of thing, so they're up there with the Magna Carta and the Constitution and the Bill of Rights and other, legal history type things. Sometimes um, that will be considered to be okay. Um, but generally speaking, the court has said that you can't just hang the Ten Commandments up in a public school classroom.
Gotcha. That's a little loophole there. Another question was, are atheists and agnostics still equally protected under the First Amendment, or over time have cases chipped away at the right to be irreligious?
Yeah. Um, technically, you technically the First Amendment protects your right to be irreligious as much as it
Mm,
protects your right to be religious.
religious. Yeah.
And the court has said in multiple cases that the court can neither prefer one religious doctrine over another, nor can it prefer religion over non-religion. In practice, they don't actually get a lot of opportunity to decide that because typically cases are brought by religious minorities and not by atheists, although there have been some. And the court applies the tests that we discussed to see whether somebody is being forced to proclaim a religion that they don't believe in, or um, whether the state is endorsing religion over non-religion. Um, when you look at things like Christmas trees in public spaces, it gets hard to say that we have the as much of a right to be irreligious as we do to be religious. But technically, we do. Yes, Nikki, I agree. To argue against "In God We Trust," it sounds good, right? But it would be a loser basically, because of the weight of history, and the court would come up with a million different reasons to say that that's not religious. Sometimes the court stands on their head in order to get to the result, and this is not a new development necessarily. This is, but there are definitely times when the justices know what they want the decision to be, and
They create a lovely word salad to get us there.
yeah, thank you.
About the use of religious rhetoric by the head of defense among military personnel, we'll see if someone obviously there have been complaints and notifications that has happened recently. I don't know if it'll ever rise to the level of the Supreme Court, but it is, I don't know, Mara, is that legal? Is that
I mean,
constitutional? I mean, is it proper? Is it,
Well,
yeah.
I mean, I would say it's not proper. Is it constitutional? Probably it's not unconstitutional. Let's put it that
Yeah.
way.
Yeah.
Because there's no, if whoever was standing at the front of the crowd said, "Okay, everybody stand up and recite the Lord's Prayer," what have you,
Mhm.
that would be a problem.
Yeah. Because that's
Um,
getting back to flag saluting and
right,
prayers at convocations. Yeah.
right. But just to have someone stand up at the front of the crowd and
Yeah.
it would be really tricky. And when you get the military involved, there's just a whole nother level.
There's a whole different
Um,
law for the military.
yeah,
So
yeah.
that's an issue in and of itself. So, but it's interesting. I mean, it's interesting when things do make it their way to the Supreme Court. Exactly like you said, sometimes they know what they want to say. Sometimes they actually do look carefully at the Constitution to see if this is going to actually fit. But the First Amendment is not a lot of words, and yet we can't even get through it in 2 hours because there's just so much that's happened and so much to talk about into the last 250 years. So um yeah
Yeah.
that's
Every president feeling that they need to say, God bless the United States of America. Yeah, it's
yeah.
hard to feel um that it's okay to be a minority religion or non-religious in this country
Mhm.
right now.
Yeah.
But I think we talked about last time, or maybe not, but things only get to the Supreme Court because somebody challenges them.
Right,
And oh, we talked about this when we did our censorship discussions, Terry. That's right.
right.
So you need to have the perfect set of facts. So to go back to Reynolds, the polygamy case, that was a test case.
Right.
The Mormon church approached him or the elders in the church said, we think you have the perfect argument
Hmm.
to challenge this law.
Right.
And so he did.
Yeah.
They may have wished that he hadn't, but so for something like that, you would need a really specific set of circumstances. Yes, in God we trust, all others pay cash, exactly. Um, but
I don't know.
those kinds of
Yeah.
things that are so embedded in our history, we would there would need to be a major shift of everything.
Yeah. That one of the questions says that the Pledge of Allegiance seems to be unique to our country. Does a similar pledge exist anywhere else? I don't know. I that's something I could look up, but I think patriotism. I know that we had a exchange student who came to visit a few years ago after many years, and we were driving around, and she said, "Why are there flags everywhere? We don't put our flag up everywhere. That's unless it's like a special day or, but everybody seems to have flags in their yard in this, and it's just, I think patriotism is something that's uh, very strong in this country, and the symbols of patriotism are kind of tend to show up a little bit stronger. So, but I don't know about the Pledge of Allegiance.
Yeah, it's interesting. I don't know if other countries have a Pledge of Allegiance, but it is um although I might be getting some information about that. Oh, my associate here. Um, many nations have a pledge to the head of state.
Oh,
So God save
interesting.
the king, for
Hmm.
example. So it is somewhat unusual that we are pledging allegiance to the flag.
Hmm.
Um, right? I mean, we should be pledging allegiance, I think, to the country the flag represents, but that's not what the Pledge of Allegiance says.
Maybe we should pledge allegiance to the Constitution if we're going to idolize the Constitution the way we do, which we do.
I
Um, that's
we say we do.
oh, the Philippines also pledges the flag. That's
Oh,
interesting.
interesting.
Hmm.
I will say one other thing about the pledge is that it hasn't been around too long. But in its original form, so when the cases that I discussed, the original form of the Pledge of Allegiance did not include the bit about under God.
I
Um,
remember. Yeah, yeah.
right? That didn't come out until that was added in like the 50s.
Right.
Um, so uh
See if I show my age by saying I remember not saying under God, but I don't.
in
So
1955, I'm being told.
okay, no.
Specific, it was all wrapped up in the Red Scare and
Yeah, yeah.
dissociating ourselves from communism, et cetera. So it's a whole nother level when you talk about that being added in. And there have been more cases um, specifically about that, but the court punted them, so we don't need to talk about them right here. Although I can, anybody who's interested, find me
We
later.
could go, we could go on
Um,
and on.
yeah,
However, it is
but
7:15.
yeah,
We have taken your time today, but again, it's this, I don't know about you, Mar, but I'm finding all of this so interesting. It's so interesting to dig into the amendments, into the cases. I hope that people are listening who also find it interesting, and look forward to the second, third,
second,
and
third.
fourth next
Yeah.
week. I think we will do our best to do that in under an hour, but you might want to get a cup of coffee or a glass of wine and hang with us for a little bit longer. We'll do our best. And thank you everybody for coming.
Thank you.
And
Thank
Thank you
you
for the great
so much.
questions.
have a
Yes,
great
thank you all.
weekend.
Have a great
Okay.
night.
Okay. Take good care.